Brown versus Board of Education, Roe versus Wade, Bush v. Gore, Citizens United, each one a famous Supreme Court case that changed the course of the country. But one case towers above all of these. And there's a pretty good chance you've never even heard of it: Marbury versus Madison. The importance of Marbury versus Madison simply cannot be overstated, and without it, all these other well-known cases might never have been decided. So what makes Marbury so momentous, and why don't more of us know more about it? In this video, we're going to meet William Marbury and James Madison, although you probably already know who he is. He was the 4th President of the United States. And we'll discover how their seemingly unimportant little dispute resulted in monumental changes to the federal government. We're also going to meet John Marshall, a true lion of the judiciary, and easily the most influential Supreme Court justice of all time. In fact, John Marshall's legacy as a jurist is so important that there are tons of people, places, and things named after him all over the United States. No fewer than 4 law schools, 2 colleges, half a dozen counties and cities, and 1 Slim Shady bear his name. Perhaps one reason modern audiences don't know much about Marbury versus Madison is that it's old. All those well-known cases we mentioned at the very beginning of the video were all decided after 1950, but Marbury goes all the way back to 1803. Now, to give you some perspective, James Madison was the 4th president, and this case was decided 5 years before he even took office. In fact, the reason Madison is named as a party in this case is because one of his pre-presidential gigs was serving as Secretary of State during Thomas Jefferson's administration. And at that time, the Secretary of State had certain jobs. One of those jobs was to deliver the commissions for certain federal appointees, including judges. And it's the delivery of one of those judicial appointments that forms the crux of the dispute in Marbury versus Madison. Now, if you think today's political landscape is polarized to an unprecedented degree, the election of 1800, often referred to as the Revolution of 1800, provides some real historical perspective on this matter. In fact, even though John Adams and Thomas Jefferson are now both remembered as important founding fathers of the United States, during the election of 1800, when they were opponents, they represented vastly differing political ideologies. Adams, running for re-election in 1800, was a member of what we call the Federalist Party, which advocated for a strong national government. His opponent, Jefferson, was the founder of the Democratic-Republican Party and a proponent of limited federal government and strong states. When Jefferson defeated Adams, Adams began the now time-honored process of making tons of lame duck appointments. Now, as a brief aside, a lame duck appointment is when a president or other elected official makes appointments or takes other official actions during the time period after the voters have elected his or her replacement, but before that replacement takes office. So the thinking is that lame duck presidents don't care about what the public thinks during this time, so they can take whatever actions they think are best or most personally beneficial. Now, the most consequential of John Adams' lame duck appointments was that of John Marshall as Chief Justice of the Supreme Court, which occurred after the previous Chief Justice resigned in order to permit Adams to appoint a Federalist judge to be Chief Justice during Jefferson's presidency. Just in case this case wasn't already confusing enough, John Marshall's job prior to being appointed to the Supreme Court was Secretary of State under John Adams. This is going to become important soon. Beyond the Supreme Court, John Adams appointed over 40 new judges in the newly created and expanded federal courts, all in an attempt to stack the courts with Federalists before Jefferson took office and tried to shrink the federal government. One of those 42 lame duck appointees was William Marbury, a Maryland businessman who had campaigned for John Adams during the election, but there was a problem. You see, in 1800, you couldn't just email somebody to let them know the good news that they've been appointed to a federal judgeship, nor could you call them on the telephone or even send them a telegram. Instead, the commission had to be delivered in person, and travel, even among these closely connected early states, took forever. But the appointments did not become effective until they were delivered, so it had to be done. Now, the result of all these lame duck appointments was that the person whose job it was to deliver all these commissions was not able to get them done before Adams left office and Jefferson took over. That person was John Marshall, the Secretary of State under John Adams. So when Thomas Jefferson takes office, William Marbury has been appointed to a judicial position, but hasn't yet received his official commission from the Secretary of State. Now, Marbury really wants to be a judge, but Jefferson really doesn't want yet another Federalist screwing up his Democratic-Republican plans. So Jefferson instructs the new Secretary of State, James Madison, not to deliver Marbury's commission. Since the commission isn't effective until it's delivered, Jefferson figures that Marbury can be blocked from his judgeship, and Jefferson will be able to appoint his own man to that job.
What?
So, it is against this backdrop that the courts become involved. Marbury sues Madison in an attempt to force him to deliver the commission. After all, he figures, delivering commissions is just a ministerial role over which the Secretary of State really has no discretion. If the President has made an appointment, the Secretary of State is obligated to deliver that commission. Madison obviously argues the opposite, and the outcome of this monumental dispute over the duties of a government official is mostly irrelevant to the bigger question of why Marbury versus Madison is such an important case. When Marbury takes his case directly to the Supreme Court, it lands on the desk of the newly confirmed Chief Justice John Marshall, the same guy who was supposed to deliver the commission in the first place. Now, at this point, John Marshall obviously recognizes his conflict of interest and recuses himself from participating in the case, as he was ethically obligated to do.
Obey the rules of the game and be a good loser.
That's a pretty hilarious joke, right? Politicians didn't care about conflicts of interest in the early 19th century any more than they do in the 21st century, so Marshall dove headfirst into the conflict between the Federalists and the Democratic-Republicans. As it turns out, John Marshall had a few things to say about the role of the Supreme Court in America, and Marbury versus Madison was just the soapbox he needed to get his message out there. See, Marshall's message was that Marbury's request to have the court force Madison to deliver the commission was not just being denied, it was being denied because this type of request was unconstitutional. Oh, and by the way, it's the court's job and nobody else's to determine whether the actions of the other branches of government are constitutional or not. And if they are not, the court can strike down such actions. The most famous line from Marbury versus Madison is Justice Marshall's powerful statement that, quote, "It is emphatically the province and duty of the judicial department to say what the law is." This is what we now know as the doctrine of judicial review. At the time, it was thought of as Marshall and the court making an outlandish power grab. In fact, Thomas Jefferson himself responded to this case by saying, quote, "You seem to consider the judges as the ultimate arbiters of all constitutional questions." A very dangerous doctrine indeed, and one which would place us under the despotism of an oligarchy. Our judges are as honest as other men, and not more so. They have, with others, the same passions for party, for power, and the privilege of their core. Their power is the more dangerous as they are in office for life, and not responsible as the other functionaries are to the elective control. However, the doctrine of judicial review persevered, and eventually everybody got on board with it. Today, the doctrine of judicial review is well settled and accepted by everyone. Brown versus Board of Education, Roe versus Wade, Bush v. Gore, Citizens United, all of these cases involved the Supreme Court interpreting various aspects of the Constitution, and when the court issued its ruling in each case, everyone obeyed it. Think about how amazing that is. 9 people have the power to radically change the course of U.S. history, and we all accept it without bloodshed or revolution. From the perspective of history, this is a minor miracle, and a testament to the stability of the American constitutional system. All this thanks to John Marshall and the doctrine of judicial review, a concept that is not explicitly found in the Constitution, but that has become a vital element of the U.S. political process. Today, any controversial law that is challenged in court is held up to the standards imposed by the Constitution. If the court decides that the law complies with those standards, then the law is upheld and the executive branch is permitted to enforce that law. If not, the court strikes down the law and it cannot be enforced. And that is why Marbury versus Madison is perhaps the most momentous decision ever issued by the Supreme Court. Now, after Marbury versus Madison, John Marshall went on to preside over the Supreme Court for 3 decades, influencing countless aspects of American life and politics. James Madison obviously went on to become the next president after Jefferson, so things turned out for him all right. And William Marbury? He went back to his business career and faded into obscurity, except for the landmark case that bears his name. I'm Michael Fricke, and this has been Case in Point, where we give you the full story of the court decisions that have shaped American society.